Hello, everyone. That was a very quick 15 minutes. I think it might have only been 10. If we have our speakers, Stephanie, Ben, and Steve, I will get started. You could all make yourself. Hi, Steve. There's Steve, Stephanie.
Hi, Steve. Thank you for all your help, as usual, Steve.
Well, thank you for an excellent presentation.
You too. Thank you. You're welcome. It's nice to have attorneys in your back pocket when you're doing a presentation.
That was very
happy
helpful.
to be here.
That helped me because I was like frantically trying to look stuff up and not doing it as effectively or efficiently as you were. Great. Now we've got Ben. Let me go ahead and introduce. We all obviously got Stephanie, Ben, and Stephen to answer some questions. And once again, so we do have people muted and their mic and their camera muted. I have a question if we'll open the microphone or do we need to type? We wanted to, just because there are so many people, do it as a text chat. But I have a few questions that didn't get answered through the beginning session. So I think we'll go through and answer those. And if we're having kind of dead air, maybe, and people want to raise their hand, I don't know, how do you guys feel, our speakers? If people want to raise their hand and feel freely ask questions verbally, are we okay with that? Yeah, okay. Let me just ask some of these. Let me just ask some of these questions first. There was a few that I thought that we kind of skipped over, but Steve, there were a few on your first, there were quite a few sessions, Steve, on your first session. So I'm just going to try to see if we can get those through pretty quickly. I kept over 4 or 5 of them. But obviously anyone can answer, Ben or Stephanie. And oh, hold on, I'm going to stop the
recording.
I'm going to stop, not going to stop the recording. I'm going to stop sharing, I think. Oh no, this will end the presentation for everyone. No. Is that what I want to do? Somebody help me. I think I do want to stop sharing.
Try going to the black share button over by the leave. Does that bring you to either stop or whatever?
Nope, that
yeah, I think if you stop sharing, Heather, it'll just display the speakers, the 3 of us and yourself if you want to be on video.
Oh, it worked.
Yeah.
Woo, phew. All right, excellent. I'm always so nervous. I'm going to turn everyone off. So Steve, one I can't remember who it was, said they have a small town. 3 of 5 members were abutters on a project. The applicant waived the requirement for the members to recuse themselves in terms of conflict of interest, and it was not a contentious project. Was this okay?
Well, I think that's very potentially problematic. I think it's difficult to irrevocably waive an abutter as board member conflict of interest. And so I would say that was probably unwise. You could probably get the most bomb-proof waiver by the applicant, and I could still see a Superior Court judge or the Supreme Court saying, no, that's just too much of a conflict. I think it's I think it's Barrington versus Davis that says you're per se excluded from participation in the land use board if you're an abutter to the subject property. So I if there's been no appeal, maybe it's fine and you're going to be good, but I wouldn't repeat the practice.
Yeah, I was thinking, Steve, even if you had an ironclad waiver from the applicant, if you had someone else in the community who was opposed to it, they might feel that, oh, you guys are all neighbors and your friends, and this was unfair. So anyone really could dispute that if they were not in favor of it or felt that it wasn't fair.
Well, actually, I think that the person who might be the person who would make that application to appeal it would still have to have standing. So
yeah,
we don't have general citizenship standing for all land use cases. So they still have to have standing. But if they did have standing and they weren't party to these releases, yes, they could certainly, challenge the decision by the board.
So there were a number of questions following up on the the recusal conversation. And so this one says, so when you were discussing the difference between legal, legislative and judicial opinions, this person says, so the recusal is only if you have made a statement of opinion in an official capacity and not as a private citizen. And I'm not sure that captures the essence of the distinction you were trying to make when, for instance, a board member may express an opinion about a topic that has come before them.
So the distinction is, if I, as a land use board member, a member of the planning board, express an opinion, a support or oppose of an application that's pending before me, where I'm going to have to make a judgment, yes or no, that creates prejudgment. I have to accuse myself, as opposed to, let's imagine for a moment, that particular application generates a discussion in the community. Maybe we should revisit how we, and this is a concern in my community as far as I'm concerned, how we decide whether or not someone has enough buildable area. We have a regulation in our town where you have to have 2 acres of buildable area, which if you have a lot of slopes, which we have in my town, and wetlands, it creates an enormous demand for a dimensional requirement. I could, as a planning board member, still take a position legislatively by discussing the issue with the select board or bringing up the matter as a question about a proposed zoning amendment. Now I'm expressing a legislative opinion, and it's not on a specific application. It's a general position that relates to a decision that might be made by the legislative body on amending the zoning ordinance. That I'm allowed to do, because it's not addressing the individual application interests that are typically being debated before a planning board between an applicant and abutters, and that's the distinction.
So one last question on that topic. The question was, say someone does express their opinion on a case prior to voting on it. They're a board member. They've said, I am opposed to this, and they don't recuse themselves. So they have stated like a blatant sort of conflict. They don't recuse themselves. What action could the board or selectmen take against that member, or to help maintain the integrity of the board's public opinion, if anything at all?
Well, the select board has the authority to remove a land use board member, elected or appointed, for malfeasance, misfeasance, or neglect of duty. And a blatant failure to abide by the obligation to avoid a conflict of interest and prejudgment could possibly deem to be a sufficient malfeasance, bad behavior by a board member that might justify removal. I'm not prepared to say it's a definitive basis, but it could be a basis for the governing body, the appointing authority, to remove a land use board member from their position.
Great, thank you. So this is a question about the Housing Appeals Board. Can the Housing Appeals Board, where did my question go? Grant legal fees or damages when you come before them? Anybody can answer this, I guess.
What the statute says, and this is one that I was always a little concerned with. The statute says that the Housing Appeals Board has the same authority as the Superior Court on similar land use cases. I think the language is something along those lines. And there is general common law that says that if you act in bad faith or your conduct was so out of line with the obligations of a land use board, there are rare circumstances where the Superior Court can award attorney's fees, but it's extremely rare. But it's not unthinkable whether the land use board, the Housing Appeals Board would do that. I'm not sure. I don't know. I don't know what Ben thinks.
Yeah, this is the first time I've heard that question, so it's particularly interesting. And I was one of the ones who worked on this statute as a legislation as it was pending, and that the language is in 679(5)(2), which reads, in exercising its authority under this chapter, the board shall have the power to award all remedies available to the Superior Courts in similar cases, including permission to develop the proposed housing. So I would say, yes, they do have the power to award that as a remedy. Yes, I don't think it's happened though.
Here's a related question that just came up. What is the primary difference between cases put forward to the Housing Appeals Board and court land use docket? Do they handle different cases?
The land use docket, there's a specific statute, it's 491-7A, that prescribes what the land use board docket is, and I need to look at that. I don't know what it is off the top of my head, but I believe it certainly is zoning board cases, planning board cases, and I think historic district commission cases. But there is a specific list of the cases that are being assigned to the land use docket, and those are the cases which are automatically now being referred to the land use docket. There were cases pending, and now there's all cases being filed now. Those automatically go to the land use board. If you give me a second, I can look up that statute.
Yeah.
And as Steve is looking that up, I'll just add that, of course, the Housing Appeals Board only handles cases that deal with housing. So if you have a strip mall, that cannot go to the Housing Appeals Board. They don't have jurisdiction to hear that case.
Right.
Okay, so it's 491:7-B, and the jurisdiction that is going to be assigned to the Housing Appeals Board. It's interesting. The language is shall have jurisdiction to hear appeals from decisions of local land use boards, including but not limited to decisions of municipal planning boards, zoning boards, historic district commissions, and conservation commissions, which is interesting because the Conservation Commission is not a land use board, but they're included. And so, but it goes on to say the jurisdiction of this docket shall not include appeals of decisions by state agencies. So it's not state agency appeals, but it's to those particular land use boards and a conservation commission that are going to be assigned to the land use docket.
Right.
I just want to focus on the Conservation Commission for a second, because as Steve pointed out, and Stephanie was nodding her head, it's not a land use board. By definition, is not a land use board. So what sorts of decisions a Conservation Commission might make that would be appealable? I think you could fashion a zoning ordinance using an innovative land use control to give the Conservation Commission conditional use permit authority to do something, say wetlands permitting in your town. That is itself appealable to Superior Court, and that would, I think, go to the land use docket.
Great. So here's one. What is the planning board's authority relative to duplexes?
There, I think I think I answered that one earlier, but the planning board doesn't really have anything over duplexes.
I'm curious about the answer, because obviously we have a lot of single family zoning, and so maybe the question is really, what is the authority for the community to regulate duplexes? Because I know we regulated duplexes just the same as any other use.
Yeah, I think these are actually two separate questions. One, the municipality through its zoning ordinance does have the authority to regulate duplexes in the same way it has the authority to regulate single family homes and any other use of land. But specifically with the planning board site plan review, remember when I was doing my portion, I talked about the jurisdiction of the planning board to do site plan review. Starts at, with residential uses, starts at 3 units in a structure or more. So a duplex is 2 units. Planning board does not have jurisdiction to do site plan review over a duplex.
Can I ask a follow-up? This is a question I have. If someone proposes a development of, say it's like a PUD, and they are proposing 8 duplexes, so there's no subdivision, it's all on one parcel, and how is that regulated? If it's there's no site plan review, they just want to put 8 duplexes on a great big lot and have it be kind of like a condominium community.
It's still a subdivision, even though the land itself might not be subdivided. If you look at the statutory definition of subdivision, it includes condominium conveyance. So the condominium is an interest in property that is regulated by the subdivision regulation. So you might create a PUD in your zoning ordinance. It's still going to be dealt with through at least the process, if not
Yeah.
the standards of the subdivision regulations.
And
Great.
that's assuming, Heather, that all of these duplexes are separate dwelling units. If they were in some fashion connected to each other, that might trigger site plan review. But
Yeah, for sure.
as separate dwelling units, yes, there are two dwelling units, and you don't have more than 2 dwelling units in each structure, so site plan review would not get triggered.
Yeah, it would be something also to just kind of take a peek at. Well, the table of permitted uses, is a lot of municipalities will have that duplexes are by right in residential zones. So just for, just to check your own regs or to see where they're allowed or where they're not allowed. But they usually are just through a building permit.
Yeah, I think in this particular situation was pretty strange where the ordinance allowed more than one building on a lot. And so it wasn't a PUD, and they actually did not want to condo it. And there was 4 duplexes. We were all not sure how to regulate it, how we're going to regulate it. But let's move along. We have a lot more questions here. This is kind of a more theoretical question, I guess. During the conversation, Steve, about the roads and subdivision and not allowing multiple landlocked parcels, one of the attendees commented that a person has a constitutional right to their property and we cannot prevent that, which seems to kind of go to the root of someone's right to subdivide their property or not in accordance with subdivision regulations. In other words, they appear to be saying you can't prevent anyone from subdividing their property. They have a constitutional right. How do we respond to that?
Well, the right to use land is protected by the Constitution, the Fifth Amendment, and also the Takings Clause of the New Hampshire Constitution, but it's also subject to reasonable regulation by the municipality. Now, that reasonable regulation is embedded in RSA 674-41. It's designed to prevent scattered and premature development where you have homes on parcels that are inaccessible by public safety vehicles, which is not beneficial to the public health, safety, and welfare of the people who live in those homes. Nevertheless, which is true, it's just true with zoning, and it's true with whether someone wants to subdivide on a Class 6 or private road, they can ask for relief from the limitations of 674-41. They can apply to the Zoning Board of Adjustment, assuming the Select Board does not grant permission to build on this or allow the Planning Board to subdivide on a Class 6 or private road. They can apply to the ZBA for special relief under RSA 674-41 Roman 2, and the ZBA can do that. So, we have ways in which we can avoid unconstitutional takings in those unique circumstances where we really should allow someone to build on a Class 6 or private road. So, for instance, let's say the person wants to subdivide to put up a dwelling that's not going to be an occupied dwelling. Let's say it's going to be a sugar shack or some other potential commercial use. That house doesn't need to be located next to a Class 5 road. It could be on a Class 6 or private road. And that's why you have this safety valve. We have a safety valve in zoning. We have a safety valve here in the 674-41. You can ask for relief and make your argument that application of that regulation to me is so unreasonable it constitutes a taking. So there is no taking if you can't prove that that's true, but you can also ask for relief to avoid the potential that the particular regulation could affect a taking.
Thank
And
you.
the United States Supreme Court, as well as the New Hampshire Supreme Court, have upheld that zoning is legal, and the municipalities and states and Euclid versus Ohio, that it is not the best and the ultimate use of the land. It is a use of the land. So that's when Steve was talking about that there, you need that relief valve. There is no taking. If I want to build a nuclear power plant on my front lawn, I'm not allowed to do that. But I can put, maybe a merry-go-round on my front lawn or whatever the case is. There's the Constitution and the RSAs are not meant to be combative against each other. the Supreme Court of the United States and the New Hampshire Supreme Court have upheld that zoning is a legal use of land for municipalities to inflict, to use probably a poor word, but the Constitution and RSAs are not in conflict with each other.
So there's a request to explain the relationship between the zoning board and the planning board in terms of exceptions and variances. So relief, I believe, is what types of relief did each of them grant?
And that was, that was kind of a little bit what I was talking about, to make sure that the ZBA stays in the ZBA lane and the planning board stays in the planning board lane. And the special exception is a use spelled out in the zoning ordinance that's allowed, but you've got to go through these additional hoops to do it. So that it could be like, I think I use the example like a doggy daycare. It just kind of comes to my head as I want to have a doggy daycare at my house. I live in a rural residential zone. But I still have to go through these criteria. So I don't necessarily maybe need site plan review, but I do need that kind of permission that the zoning ordinance says a special exception is required to have a doggy daycare in their rural residential zone. So a special use permit with the planning board is something that, like a particular, use of land, a wetlands district. I want to have a driveway. My house is way in the back and I have to cross a wetlands, to get to my driveway. Well, that way we need a special use permit instead of just a driveway permit, where there's special conditions of the land that have to be taken into consideration before you can approve that. So that's, even though it's a little confusing because special use, conditional use permits are in the zoning ordinance, the planning board administers them. And I don't know the RSA right off the top of my head right now, but I bet you Steve and Ben know the innovative land use control. Is it 674-21?
Yeah.
Indeed.
Yeah. You did know.
I did know. Yeah. So that, I hope that answered your question, and that's why it's important in my trainings. I've said before, I know that Ben and Steve have said before too as well, is that planning boards and zoning boards, they need to get along, they need to cooperate. We're all on the same team, but you do have specific charges, and yes, those charges can get messy and maybe cross over now and again, but ZBA needs to stay in their lane and planning board needs to stay in their lane.
And I would just add that, oh, go ahead, Ben.
One thing I'll add is that I think even more important than getting along is that they have to respect each other.
Yeah.
So I think from a people's trust in government, for one board to be bad mouthing another board is really not good for overall town government. And I think, when say a planning board is making a decision, if it is a question of zoning interpretation, yes, the planning board can and does interpret the zoning ordinance. Those decisions are appealable to the ZBA. And if the ZBA overturns the planning board's interpretation, the planning board is obliged to follow the ZBA's interpretation.
Except where the innovative land use controls come in, right? Don't those go directly to Superior Court?
Appeals of decisions made by a planning board under an innovative land use control go straight to Superior Court, yes.
The follow-up question to that. Oh, I was just going to add the basic, like, ZBA gives variances, planning board grants waivers, just at a very basic level. The planning board grants waivers to their regulations. The ZBA is able to grant variances to the zoning. I often have found people get just the basics a little
Correct.
bit confused.
Yep, exactly. And again, that also goes back to sometimes you got to be really specific about what terms you're using.
Right.
And sometimes boards say, oh, I grant a waiver. Oh, I got a variance from the subdivision regulations. I'm like, yeah, you kind of gotta be a little bit more specific from that.
Yeah.
But, and again, we're talking about, conditional use permits or special use permits to even make it a little bit more confusing, is that they are in the zoning ordinance, but they're in charge of the planning board.
Right.
So the planning board can work within so again, it's important for the planning board to keep everything that you're in charge of straight, what you can and can't do.
Here's a great question. What's the best way to assure that an update to the master plan is not just shelved and never consulted again until the next update? Should action items be developed, or should the planning board just designate a periodic review? Give us your thoughts.
Yeah, I think a periodic review is crucial. You know, in all my years of staffing boards and planning boards, there was only one member that I ever encountered, and he was very faithful about bringing his master plan to every zoning meeting and just being that one person to say, hey, okay, our nuclear power plant's really what the town wanted, but let's check the master plan. So in essence, should board members, you know, be utilizing the master plan in their decisions in a removed way? Yeah, you kind of should. But another way to keep track of them is, yes, set a yearly annual review, whether it's CIP. That's another good time to look at, you know, reviews in your master plan. With a CIP, you know, sidewalks to the library, that's in the master plan. You know, all those kinds of things are all in the big circle of planning. So to ensure that the master plan isn't just a really expensive book that sits on a shelf and gets dusted off every 5 years or 10 years, zoning amendment time, you know, crack it open, see what needs to be done. CIP time, you know, what if, you know, a new park was created or built within the CIP program, and that's something that should be updated in the master plan. So it's important for staff and for planning boards to always keep the master plan at least somewhere on your radar, just not every 5 years where you dust it off.
When the master plan committee that I worked on in my town, we made sure that each chapter had a list of goals that this part of the master plan suggested we need to achieve for this particular element. Hey, here's the housing element. And at the end of the chapter, we had a list of goals that we should try to work towards, reflected by that particular section of the master plan. And then we had an implementation chapter. And the implementation chapter was the last chapter. We collected all those goals from all the sections. And in there, we had assigned to ourselves a timetable when these things would be addressed. And we would deliberately bring out that implementation chapter in September, October each year and say, are there things that we need to amend in our zoning ordinance or even a CIP, which are reflected in the things we said we would do in the implementation chapter? And so you just to build into the book itself, you know, a process of regularly going back and recognizing these are our goals. This is the timetable we set for us to achieve those goals. And are we working towards that every year? So that'd be one way to do it. You know, it might be for some towns, I suppose, just doing that once a year might be an empty exercise. If you're really diligent board, it's not an empty exercise. You are regularly looking back on what you said you wanted to achieve and trying to push towards those objectives. So that's one approach that I think would be avoiding it being a, you know, a doorstop, not considered or addressed.
I think too, and Steve mentioned the implementation chapter. Within the implementation chapter, it's not just about the planning board, but you'll have multiple boards being involved, and maybe some non-governmental organizations as well who might have responsibility to do something. I think it's important to get their buy-in during the process of developing the master plan, not spring it upon them after it's been adopted, so that you're more likely to achieve those goals in the end.
Great, thank you guys. So question here on the statutory deadlines. Can the applicant agree to extend the initial 30-day window for the planning board to hear their application at a public hearing? And this question is in relative to third-party review. And there was another question, Steve, that you'd answered. Does the third-party review extend the 65-day deadline? And you said, no, it doesn't. And I just want to share that in my experience, applicants regularly did agree to extend that time period in order for their third-party reviews, if needed, to be completed. So I believe the answer to that is that yes, you can, if the applicant agrees, if you get it in writing, if you get it on record, so you can be sure that you can justify that.
Well, part of the third party review, I don't know, I think I saw a question dealing with third-party review before, before acceptance. Well, part of the third-party review is the planning board having jurisdiction. So you can't have, the third-party review be done before, a complete third-party review. You can, in some communities where, you've got that engineering, in communities that I worked for, you had an engineer review. There's an engineer on contract with the town that every application that came through. And that was a minimum fee at the beginning for a major site plan or major subdivision. They would do the town engineer would do a precursory, review. But a third-party engineer review is can be utilized, after they've taken jurisdiction over the application and say, yes, we need a traffic study, or yes, we need, this type of expert. So it's a little bit of a different, a little bit of a nuance there is, I love third-party review. I love having a town engineer on staff as well, where you build that in right from the beginning. The applicant is aware of it. The engineer is there. There's that third-party person is working on every application for the town.
Yeah, and I think the alternative, Steve, is when you were talking about, is that you deny the application without prejudice because you simply haven't gotten the information required to make the decision. Yeah. So that's typically why the applicant will agree to the 30-day extension or however much time is needed, really, because the alternative is that they're going to have to start over again after that's completed when the application is denied without prejudice.
But I think the other thing to keep in mind is my experience being on the planning board. If you are working in good faith with a project and a developer who's developing that project, and you're having a fair sharing back and forth of information, and it's pretty clear the board is not just putting up roadblocks. Generally, applicants are willing to work with you. If you need more time, they'll probably give it to you. Mm-hmm. If you are in a more adversarial mode and things are not going well in the relations between you and the applicant, you're going to find it harder to get those consents. So it can sometimes come down to the nature of the working relationship between the board and the applicant.
Yeah. This is an interesting question. Do you guys have any suggestions on how to incorporate a public input session, meaning a period of time at each meeting where members of the public are able to speak on matters not currently in front of the board for review? How to incorporate that type of session into the regular planning board meetings?
You could have a just another business item on an agenda. Maybe at the end of the meeting or something. What do you guys think, Ben?
Yeah, public comment period.
Yeah.
You if you're the chair, you want to limit the time that people speak. Minutes or, but yeah, there's no reason you can't allow for public comment.
I cannot hear Ben. Does he need to adjust his microphone? Can everyone else hear him? It's just me. I mean, I can hear him, just not well. Sorry, maybe just me. No one's nodding their head. Better. Yeah, I can hear you better now. Sorry, go ahead.
Go ahead, Stephanie.
Oh, sorry. I thought we stay on topic. I'll catch you after, Steve, because I found something someone wanted a question for. So go ahead, Steve.
I was just going to say my select board has that practice at the beginning of every select board meeting. You can come up to the select board and take 2 or 3 minutes on any topic. Mm-hmm. I'm not a fan of that idea, but I certainly understand that it's going to allow a lot more opportunity for citizens just to raise concerns. And there may be things you would hear as a planning board member you didn't even think of. And that's the benefit of a public hearing process, to hear things you weren't thinking of. So sure, it might be a good idea. It certainly has to be controlled in terms of time and how much allocated time is available for it. But a board could do it, and it might work out great. Might blow up in their faces. It depends.
Right. Yeah. I mean, I used to try to coach my boards, is that I'm a big fan of just being transparent and giving everyone an opportunity to talk. You can put time limits, you're there to, people want to be heard, and giving them an opportunity. Hey, planning board, when are you going to update the master plan? There's nothing wrong with that, with people, you want people involved, and so having a free-for-all kind of thing at a planning board meeting within reason, I think, is appropriate. And quickly, before someone asked me during my thing, I believe the question was, Where in the RSA's does it say how many members the planning board is to have? And it's based on, town council form of government and town government, and it's 673-2. It's called, it was from our handbook. For those of you who want to take the planning board test, and it's probably a question you may find on the planning board test to test your knowledge. But it's 673-2 is the number of board members. And as I'm scrolling down, I also just wanted to see quickly, there was a question, there was a question about serving on 2 boards. Can a planning board member serve on a board? And I'm only answering this quickly because it's also in our handbook. 673-7, planning board, the law prohibits more than one planning board member from also serving on the Conservation Commission, Board of Selectmen, or any other local land use board, such as Zoning Board of Adjustment. So you can have a planning board member who is a zoning board member and a planning board member, but you can only have one. And then if you go down that road, then if an application comes in for a special exception and it needs site plan, then that member can choose which case that they're going to sit on or which one they're going to recuse themselves from, because they really shouldn't be sitting on both. So that you can have a planning board member who's also a zoning board member, or
Great.
vice versa.
Thank you. This is a chairperson of the board, and they don't have a planning director in their community. And she says she's in the office and regularly meets with applicants to discuss their application and citizens that need information. And she's hopeful that this does not cause an issue when the applicant comes before the board. Is there any concern? Is there anything she should be concerned about there?
I think there is room for concern.
Yeah.
Now, I think it's great to be providing good customer service and to be helpful. The problem, of course, is that the chair is a member of the board and votes on these applications in effectively a judicial capacity. So to advise an applicant on what they should or shouldn't be doing has started creeping toward prejudging an application. So I would be very careful about that and try to limit your interaction with the applicants about finding things, where to find these resources, filling out a checklist, but not to judge the substance of an application until the rest of the board is doing it with you in a public setting.
Right, and that's, I think, the better approach, rather than have the chair delegate that responsibility to give feedback or input to an applicant. Use the conceptual consultation process.
Yeah.
Allow the person to come in a conceptual consultation and go over whatever the concerns the person has, discuss the issues you think might arise, and you've done it legally and in compliance with the statute, and you've given the person the feedback they need. I think that might be the better approach. It does require a full meeting of the planning board and notice under the right to know law, but you don't have to give a butter notification for conceptual consultation. So that might be another approach.
Yeah. And other times, and I totally agree with that conceptual consultation, and other times what we've done, or I've done in the past, is that if your community has a TRC, that's also kind of a good opportunity to help an applicant through the process before they do a formal application, is to come in and sit with, and you go, I love third-party review and I love TRC. So TRCs are department heads that can meet and help an applicant through an application. So those are other little cheap 15 minutes in front of a committee if they're already meeting or have a special meeting for that. Conceptual consultations, I used to put like a 15-minute time limit on that so that you don't get into too much detail, just generally speaking for that application. And they're very helpful. It's helpful to the board and to the applicant, and it's not that much effort, and you're doing it without the impression that you've given favoritism or helped an applicant extra than anybody else.
Great. This person's asking, what are the consequences to the planning board not adhering to the timeframes for accepting and hearing an application? And I think the part of the answer might be, what are the consequences, but what recourse is there if the planning board is not doing that? what steps does someone need to take to correct that?
Well, I think you got to go to court. That's
Exactly.
that is the means of enforcement. Although 676.4, which has changed recently, used to, for the 65-day clock for subdivision and site plan applications, used to have a role for the select board to extend the time. You could petition the select board, or the planning board could ask the select board for more time. And that's if the applicant isn't giving you the additional time by mutual agreement. But now that the 65-day deadline, if the applicant says, no, I'm not going to give you more time, that has become a harder deadline. So you really have to meet that. Or as Stephanie suggested, you deny the application without prejudice if there's not sufficient information, or you deny it with prejudice if the application's not good enough to meet the standards of your regulations.
Yeah, it does. It is bothersome. And I did see something in the chat about that, about an applicant trying to get a fairly simple, not a huge technical or huge in size type of development through the process. And they've just been getting the runaround, and a municipality to say to an applicant, we're too busy to put you on a planning board agenda is I hate to spend other people's money, but and I'll totally, let the two attorneys, give the legally sound answer, but that would be the time to start to get an attorney. And unfortunately, but a town is acting that way, which is not fair. It's not productive for a town to be acting that way. And your recourse is, talking with maybe, town management, maybe the selectmen, maybe the town administrator. Sometimes they don't even know what the planning board is up to. So those things can be very eye-opening for selectmen or for city council or town council. But unfortunately, if you're getting a runaround from the town and you've hit a wall with administration of the town, then I guess, your next step is legal recourse.
It always concerns me when I hear about, say, planning boards pushing things off because they have too much stuff on their agendas. You've got an obligation to hear these applications. And if that means scheduling more meetings to do them, then that's what you've got to do. It also concerns me when I hear situations where staff sometimes act as gatekeepers to what gets on an agenda. There's too much going on that agenda. I'm going to push you off to the next month. No, if you've got an application that is sufficiently complete for the board to accept jurisdiction, then the board is obliged to have that on its agenda.
Mm-hmm.
I see a question in the chat that I'd like to tackle, and this is
Sure.
Eric. Can no, it's actually up here. If the municipality has an interest in increasing low-income housing, okay, how do you engage with the developers to discuss incentives, density bonuses, tax abatements, provisions of infrastructure, other? Who does that? City council, city administrator, planning board? Yes. So there's not they're not clear dividing lines here about who does what, but if you're dealing with tax incentives, for example, RSA 79E, that is a local legislative body and local governing body question. It's not so much a planning board issue, although it could come up, say, in discussions of a master plan. It's not a land use regulation. But it is a really important incentive that many communities have adopted to provide additional vehicles for getting things done in town. But as far as it goes for providing land use incentives, zoning incentives, That's really part of the master plan process. And so the planning board does want to be engaging with developers and other people to talk about what sort of incentives would induce developers to do the things that you're asking them to do. And then you put that into your master plan, and that's a recommendation for a zoning amendment. Then the planning board, you work on the zoning amendment. And there too, you work with developers and any other interested parties who have an interest in this to come up with zoning incentives that provide adequate incentive for developers to do the thing you're asking them to do. And then you got to convince the voters to adopt it.
Thank you. I want to share, Ben, that I had accidentally muted myself and was reading that question, and I was 3/4 through it, and you go, "Oh, I see one I want to answer," and I'm like, "Why is he talking over me and reading the exact same thing?" Anyway, look, great minds, Ben. Great minds.
Yeah.
So the question right after that is a bit more of a public input question. Can you give suggestions on ways to solicit input from all people in town? And I just want to say that there are planning consultants and other types of consultants paid oodles and oodles of money to answer this question, and it takes them months and months and months. So go ahead, guys, give them an answer in a few sound bites.
Well, the HOP committee, the group that is helping distribute assistance to communities through the New Hampshire Housing and BEA, has been using the services of the Housing Academy at the, help me out, Ben, UNH Cooperative Extension Housing
Right.
Academy. And they have a whole group of trainers who are doing programming designed to assist citizens and land use board members how to better understand how do you move a proposal to amend the zoning ordinance that would encourage more affordable housing. How do you move that to yes? And so I would encourage you to think about connecting with UNH Cooperative Extension and their Housing Academy.
And I would encourage folks too, if you're interested in engaging this process, you can go to NHOPgrants.org. It's HOPGRANTS.org. And that's where you'll find information on these housing opportunity planning grants funded by BEA through New Hampshire Housing.
Great, thank you. So here's a question. Can the planning board, this is actually like a 4-part question. Can the planning board propose zoning amendments? Well, actually, or adopt subdivision regulations or site plan regulations that ensure that there is adequate water quality and quantity for applications, including consideration of water impacts of existing residents and businesses?
Well, I could just tell you one experience that I had on the planning board where we were being asked to approve a project, and they were planning to put in wells for a multiple unit project. And it just turned out that the project was going to be located not too far away from our closed landfill. And we told the applicant, we have some concerns about that location and where you're planning to put your wells. So we required them to do a pump test to see if that would, the pumping that would be naturally used for the water for the units, the dwelling units, would that in some fashion draw some of the bad stuff from underneath the landfill towards the units. And the concern turned out to be, yes, that would. And we had to recommend that the applicant seek an alternate water source, which they were able to do. So that's kind of a application specific. I mean, I don't think it's unreasonable for a planning board having its subdivision or site plan regulation, a regulation that would address in those circumstances where there is concern for the amount of groundwater in a particular area, or whether or not there have been previous complaints from abutters about loss of water because of a low ground table, that be taken into account, and that testing be undertaken to ensure that drawing out more water from that already perhaps compromised aquifer won't harm the existing wells in the area. Those would be, I think, reasonable things to have in your regulations to address this particular question.
Thanks. I would second that too. In Concord, where I worked, we regularly, once we realized that we may have some infrastructure issues, we regularly started asking bigger developments to do third-party studies on the impact on our system. So that's something that we've done pretty regularly.
And this is where, local knowledge can be really important. So years ago, I was the planner in Hollis, and we were faced with a small subdivision. It was 4 or 5 lots. And, but, the folks in town knew that this used to be, it was the site of a former pig farm. And, this is a place where restaurant waste was trucked up from Boston to feed the pigs. And there were a lot of pigs there, and they were slaughtered there. So there was concern about contamination of the groundwater from the pig waste. And in fact, so the planning board required the applicant to do some testing of groundwater. And it turns out there was a plume of nitrates there. So ammonium nitrate, I believe. And so as part of the process, the applicant had to remediate the contamination of the groundwater. It was expensive, but in the end, ultimately worth it. And as a souvenir of that process, I have a little piece of china here from one of those restaurants
Oh, that's great.
from Boston. I think from Jimmy's Harborside.
That's great. Thank you for sharing. This is very politely worded question. Can we ask an applicant who wants to build 20 home development to create a few of those to be affordable housing?
You can ask.
Yeah. Is it, are we at a point that you can put, I'm trying to think of what legislation is out there right now. Can you require affordable housing? It's part of one of the things that you can now require.
You cannot.
Okay.
You can. So this is part of the innovative land use controls. It's called inclusionary zoning. And under New Hampshire law, a municipality may develop standards that voluntarily induce a developer to build affordable housing instead of market rate housing or in combination with market rate housing. This typically takes the form of density bonuses. So instead of 20, maybe they get 30, and 5 of them or 10 of them have to be affordable. So that's the inducement. So you get more housing as long as you promise to do some of them as affordable, and you can impose legal restrictions on the ones that are affordable to ensure that they are in fact affordable and are of benefit to the people who they're intended to serve. So you can do those things, but it has to start with the premise that it is a voluntary inducement.
Thank you. Is there legislation pending that you can require it, or am I making that up? That's wishful
for the past
thinking.
2 sessions, there has been legislation, and both years it has been killed.
Gotcha. Can a developer avoid a bond if they do not sell subdivision lots or request building permits until after the road is completed and accepted by the town?
Well, this is what the amended statute says, 674:36 Roman 4. The planning board's limitation under this section dealing with letters of credit, cash, et cetera, as the only method of securing the completion of the work. So you have certain limitations of what you can require in terms of the forms of security. Then it goes on to say a planning board shall allow road and utility construction to start without a bond. However, a bond for the infrastructure, roads, and utilities must be in place prior to the sale of any parcel of land within the subdivision or a request for a building permit for structures for human occupation. And then it goes on to say the planning board shall not require that forfeiture or automatic call bonds be provided by the developer. It's something that used to be commonly used back in the 1980s. So yes, you'll set the performance bond amount. You will probably recommend that it be a letter of credit, which is rare to get these days, or a bond issued by an insurance company, such as Maine Bonding. And then that will not be required to be posted until this step of the proposed sale of a lot or the request for a building permit, so that developer can carry out road construction up to that point, and then a bond might be necessary if they want to sell a lot or get a building permit.
Great, thank you so much. I am not seeing, so there are a few posts. Oh, on current discussion, I think, Ben, this is what you were talking about, on trying to induce developers to come to town. Do board members create a conflict of interest?
It depends on what you're talking about.
Yeah,
If you're
I
talking
can't hear
about,
you. Move your microphone a little closer again, if you wouldn't
yeah,
mind.
if you're talking about a specific site that a developer has an interest in, then it's not a conflict of interest, but because you, the board member, don't have an interest, a financial interest in that, but you could move into prejudging an application by encouraging them to do this specific thing. But if you're talking in generalities about development and, say, ask the developers, what sort of inducements would get you to do this? And they might talk about specific levels of density that they need to achieve the economies of scale to produce affordable housing, then that's probably okay. And again, this should be part of an organized process, whether you're developing the master plan or amending your zoning ordinance.
Great, thank you. And I see, Stephanie, that you just responded to a question that I completely missed on a master plan. Putting together, they asked for suggestion ways to solicit. Oh, that was the one on the public participation. Yeah.
Yeah, I was just saying, get creative, have fun.
No, that was good. I like that.
Yeah.
And then someone posted this section that I'm not sure why they posted it, but it was about power to make laws, elect officers, define their powers. And I'm not sure what if there was a question or if they were responding to something, but there's a long post there. And then we did have someone saying, thank you for covering many useful topics today. Once you make these available, I will download them as reference for board members who did not participate, which is great. I mean, that's awesome if you think that it's valuable to you that you're going to share with your other board members. And we appreciate that. That's why we're doing it. Do any of you?
Heather, I was just going to say, is there any, going through some of the roundtable questions? Are there any there?
Oh yeah, we've got 20, we've got pages and pages of roundtable questions, but what time
can
we
play
go
a little
to?
true false.
Yeah, but what time are we go to? Is it still, I thought it was 3:15. Is it?
We go to 3:30.
Oh, okay, great.
I did want to jump in real quick. I saw one question, is a groundwater conservation overlay district considered an innovative land use control under RSA 674:2? I would just say, here is a really good book. Hopefully you can all see it. It's called The Innovative Land Use Planning Techniques. It was published by, DES, Regional Planning Commissions, Office of Energy and Planning at the time, BEA now, and NHMA. And it's an excellent compendium of a lot of stock proposed innovative land use control regulations, including groundwater protection regulations. So this book is electronically available at the BEA Office of Planning Development website. So you can go there, and it has a chapter just on groundwater conservation. And it also has a suggested ordinance that you could potentially modify and then adopt by your community. So it's an excellent book, Innovative Land Use Control Planning Techniques, and would recommend it as a guide towards that particular effort to have a conservation overlay district, groundwater conservation overlay district.
And I would say, add to that, the folks at DES are really helpful in this. They have people who specialize in this specific work.
Great, thank you guys. We did get another question about impact fees. Can impact fees be collected for school projects, for repairs, maintenance, or expansion?
Expansion, yes. Maintenance, no. Impact fees are not for operations and maintenance.
Yeah.
Impact fees have to be expanding the capacity of your capital infrastructure to absorb new growth. It is not for pre-existing deficiencies, such as repairing something you've already had an obligation to take care of.
I would also include, like, for instance, if you're doing an expansion because you want to add a gym and you don't have a gym for whatever reason, that's not an expansion of capacity necessarily. That's an expansion of to serve maybe the existing kids that are there.
Well, that may have been an underlying deficiency in the infrastructure, not having a gym that may have been deemed sufficient or necessary if you look at national standards for what should be at high schools or middle schools or elementary schools. But that's not expanding capacity. You're expanding capacity when you're putting in new schoolrooms And that's because you have an increase in the school population, which tends not to be the case in most school districts these days.
Right. Yeah, that's the case in Concord with the new school they're constructing, that expanding capacity, so we cannot create fees to help fund that. Let's see. Oh, thank you, Stephanie, for posting about impact fees. I'll jump over to the roundtable. The questions that I had pre-written questions. How do we enforce compliance with approved site plans and subdivisions?
I'll tell you what we did. I tell you what we did on our planning board. We scheduled, not as regularly we should have, a review of a previously approved subdivision or site plan. And we would ask the building inspector or the planner, what's going on with this project? Where they stand? Are they building it? Is this being done according to plan? I actually remember a couple of times we did site visits at a project that was being built. And I remember one time going out to see a project being built saying, hey, what is that temporary? They had a small device that was used to fill up fuel for the equipment, and it was sitting right next to the stream that we took a lot of time protecting. And I said, wait a minute, you can't do that. So, but that's the planning board in really taking an active role. You're not an enforcing agency as the planning board. That's not your job. But, asking questions about what's going on with the project. Are they conforming to the plans and specifications? Maybe getting a report from the inspection engineer if you have one. That's not unreasonable, to make sure it's conforming to your expectations and the terms and conditions of approval.
I would add to this too that remember what I said in my session with regard to site plans and subdivisions. If you're requiring some sort of surety to ensure the performance and completion of improvements, you, the planning board, are in charge of those bonds and releasing them, which means you've got to ensure that what has been promised has been done as you release the bonds. Also, you have, as a board, the ultimate big stick, and that is revocation of approval. It's rarely used. It's hard to do, but it is a very, very big stick. And so if you got something that is way out of compliance with your approval, you might need to consider revoking the approval. That will, of course, wind up in court.
I'll tell you what we did one time in a very complex project in a town I represented. They were way out of compliance, serious offsite drainage problems. There's a statute that says the building inspector shall not issue any building permits or occupancy permits if the project it's in does not conform to the planning board regulations and decisions which have been made. So we teed up with a notice to the applicant. The planning board is going to have a show cause hearing to show cause why the planning board should not find that this project is out of compliance with the terms and conditions of approval, and to recommend that the building inspector cease the issue of building permits and certificates of occupancy. Now that really got the developer where they were going to be hurt because they were actively constructing projects. They had to sell units in order to make money. That got their attention, and they promptly got before the planning board. We developed a plan with them to rectify especially drainage issues, and it got solved. So, you can do a little bit of creative activity through the planning board to compel compliance with those terms and conditions of approval.
Great, thank you. Speaking of what you just referenced, a site walk, how do we handle a site walk if the board wants to do a site walk? Are attendance and minutes required?
Yes.
Yes.
Yes, yes, and yes. It is a meeting. And recently I've come across a few instances where site walk minutes were who was there, and that was it. You need a little bit more, planning board members reviewed the site is not really adequate for minutes taken at a site walk. But yes, it's a minute, it's a meeting of the board. It has to be noticed to the public, and minutes have to be taken, and you don't have to have verbatim word for word, but you should have issues that were talked about? Were they concerned about screening? What did they talk about? Did they resolve? Is there issues? You can't just say everybody was there at 5 and left at 6. That's not really
And then
adequate.
someone's asked, is the public entitled to attend, or how does the public participate in a site walk?
Yes, it's a public meeting. So yes, they are entitled to attend. And I think somewhere maybe Ben and Steve can answer. If the applicant doesn't allow butters on the property, then the site walk can be canceled. Is that ringing a bell? Something?
You can't make the applicant allow the everyone, because it's a public meeting. You can't conduct the public meeting site plan, site review, unless everyone is entitled to go on the property. And the applicant says no, then you say, fine, we won't do a site visit. And, I don't think that's typically beneficial to the applicant, because site visits typically, from my perspective, usually helped us understand what we were about to do, and generally made the board better informed. And if you're putting a roadblock in the ability of the board to be better informed, it's going to be harder for the board to make a decision in your favor. So I don't know why an applicant would do that. Sometimes they argue about someone trips and falls, I'll be sued. I don't think that's a serious concern. I think it's more concerning if the board doesn't have an adequate foundation of knowledge, which a site visit is an extremely important part of the process. And you can't do a site visit if the public can't attend.
Mm-hmm.
So my
How do you-
community, oh, go ahead, Ben.
How do you feel about individual board members going to a site alone?
That's okay. I
Yeah.
mean, I guess they can do it, maybe a windshield tour. Yes, and then it's not a public meeting. But, the interactive process that I've found with board members sharing ideas, and one person asks a question, and then you're bouncing ideas, it generally is beneficial to have the whole board there. But yes, you could do it by individual members.
Yeah. That I used to also, tell my board members, if they can't make a site walk, go do a drive-by, observe from the street, observe from your car. But drive-bys and one person going on their own out of a site walk is totally acceptable. I think it's really important. Steve, don't you do site walks for all your applications? Was that ZBA that you guys do that?
ZBA,
or-
we do site walks for all ZBA applications also. And we
Yep.
do them on the night of the meeting. Now we got light now. In the middle of winter, it was kind of hard to do. We did them on Saturdays, but now we'll do them, at 5:30, and our meetings at 7. And
Yeah.
we usually can fit in sometimes 2, sometimes 3 site visits.
I think that they're great. I think that, put them right on a list of stuff that I love: TRC, third party review, site walks. I think it gives, the board a real perspective to be there. And I'm a real visual person anyway. So I would, you can imagine and visualize what STIFA is, what time of day, other things that you may not even think of when you're in a meeting can come up at a site walk. I noticed there's a school, 2 blocks away. What about traffic? All those kinds of things that you can gather from a site walk that you may miss by just going through the normal process of an application. So, but they are a meeting. Don't forget to notice.
My community wrote into the regulations, so maybe you can tell me if this is legal or not, that submitting an application automatically grants the right to enter their property for a site plan review. So it says essentially when they are submitting the application, they're agreeing to allow access to their property. Not that we wouldn't contact them or let them know, but that they're agreeing to that access. Is that legal?
Well, I would prefer that there be an affirmative statement as part of the application documentation where the applicant says they're granting consent for access. I'm a little bit hesitant to say just having the application document presume that that's what you've granted. I'd rather have them, a checkbox. Yes, I consent. I would prefer that approach rather than presume you've granted that permission by merely submitting an application.
Gotcha.
I don't like that as much, I guess I would say.
Yeah. I was curious. That's why I asked. So someone's asking for the statute that states that innovative land use controls don't go directly to Superior Court and do not go to the ZBA. and I do not know what section that is.
Yeah, it's section 21, and what it says is as follows. It's RSA 674:21, Roman 2. And it says, oh, wait a minute. No,
That's
that's
where-
not it.
That's
not
where
it.
innovative.
It's,
That's where the innovative land use controls are, but I don't know
no,
where.
I was looking this up too.
It's in appeals. It's
It's in the
676.
appeals.
676, right?
It's administrative appeal. It's when you appeal to the ZBA, it says 676. It's appeals to the board.
5.
Is it 5?
I
No,
think it's
it's
5.
Roman 3 of 676:5.
Yeah.
It says if then provided, however, if the zoning ordinance contains an innovative land use control adopted pursuant to RSA 674:21, which delegates administration, conditional use permit at the planning board, then the planning board's decision made pursuant to that delegation cannot be appealed to the Board of Adjustment, but may be appealed to the Superior Court. So that's where that is. It's 676:5, delegating only to the Superior Court the power to review the planning board's decision under innovative land use controls. Now, I've had this debate with a number of land use lawyers. A number of them take the position, I'm entitled to request a variance from anything under the zoning ordinance. You can't say I can't ask for a variance. And I guess that's theoretically true. If you don't want to go for permission on the conditional land use permission, you can still ask for a variance. Let's say the use was allowed by conditional use permit, and I don't want to, go through the planning board's process. I suppose you can ask for a variance to have that use allowed as a use variance. But ultimately, I think that the answer is if you have a conditional use process delegated to the planning board makes a decision you don't like, your appeal rights are to the Superior Court, not to the ZBA.
Yeah, thank you. Here's a great question. Is a failed motion mean the application is denied or approved?
No, it means nothing.
And what do we do next?
You got to make a motion to approve or disapprove. You can't let it lie there. It doesn't work.
A failed motion is not a denial, nor is it an approval, right, attorneys?
It's neither.
Yes. So it's interesting because I posed this very question to, and this was probably 20 years ago, to the online site for the Roberts Rules of Order. There's this essentially a club, and their view was that a failed motion to approve is a motion to deny. And I vehemently disagree, because there are many reasons why someone might oppose a motion. And not all of them are because they are opposed to the approval. They just, it may be you didn't list the condition I wanted.
Right.
So I think, Steve and Stephanie, I think you're saying yes. So I agree completely. The next step is do another motion. Add your condition for approval, or make a motion to deny. You have to have an affirmative action to do something, which might be to say no or to say yes with these conditions.
Yeah, I had a very bizarre case where the motion failed like 3 times, and then the chair got really flustered and said, "Well, that's it, you're denied." And then the people shuffled out really quickly. And I don't know if this was correct, but the next month I said, "Listen, guys, you can't do that. We got to bring them back. You got to make a motion. You got to figure it out. You can't just be like, 'Well, sorry,' and throw your hands up and then shuffle them out of the room."
Right.
So fortunately, they did get their approval. Is the moral of that story. So it is 3. Oh wait, we got one last. Is it 2-2 tie vote to approve and 2-2 tie vote? What happened? Oh, that's kind of what we just said. You just got to keep going until if it's 2-2 to approve and 2-2 to disapprove, you just got to figure it out. You got to keep going until you figure it out.
Yeah.
It's got to go one way or the other.
Yeah.
It is 3:30. We've had some great questions. I think we've done a pretty good job of addressing just about all of them. I'd like to thank you guys. Is there anything further anybody wants to share
I do have
or address?
a quick easy one there. Heather, I just saw it says, can a planning board member in doing his own site visit or research stop to chat with neighbors or the owner?
Oh, yep.
I wouldn't chat with the owner, but I mean, there's nothing wrong. I mean, I don't know. I'll let the lawyers answer, more legally correct, but I don't see a problem with talking to neighbors, but I wouldn't talk to the owner. If you want to get a feel for the neighborhood or traffic or
Yeah.
whatever else is going on there.
I did realize that like 4 questions have got posted in the last minute. I don't know if you want to answer those or if we want to.
Well, just quickly, it just indicates the reason why it's better to do the site visit with the entire board.
Yeah.
The individuals doing these things always has the danger of somehow it being argued what the board member says is indicative of prejudgment. I would say that there is a case about abstention. It's McRae versus the town of Merrimack. And in the McRae versus town of Merrimack, the issue was whether or not the abstention of a member, which resulted in the board not being able to have a majority to vote in favor of a certain action, whether that prevented the board from making a decision. And there's actually a New Hampshire Supreme Court case that says if you abstain in certain circumstances, you're deemed to have voted with the majority. And so abstention generally cannot be used to thwart what a public body is going to do because, okay, you've abstained. If it's a 2-to-1 vote and we need a 3-to-2 vote, you're going to be deemed to have voted with the majority. And so that's just something to keep in mind. Abstention generally is not beneficial to you as a board member because you're avoiding your duty as a board member, and you might be considered to have voted with those who are on the majority of a motion.
Of course, if it's otherwise a tie vote, then there is no majority and the motion
True.
fails.
That's right.
Well, if you've ever attended my trainings, you know that I do not recommend that board members abstain, right? You've been put there to vote and make the hard decisions, and not everyone's going to be happy with your decisions, but you owe it to the people who voted for you, who appointed you, to the applicant, to everyone in attendance, to not shirk your duty and to vote.
Right. And without casting aspersions, I'd say get a backbone. Vote.
I did see this one last question about variances, whether you need a denial for something first before you can apply for a variance. No, if you know that your use is not permitted, if you know that you don't have the correct dimensional requirements, you do not need to wait for anyone to tell you that. You can just go ahead and submit an application to the ZBA for the variance. Very straightforward. And then we got a whole lot of thank yous.
Good.
So thank you. Yes,
Thank you. Thank you again for Ben and Steve for volunteering your Saturday. It's
been a pleasure.
Very appreciated.
I love doing this. I love doing it.
You guys have been great.
And Ben is so mellifluous and smooth with his presentation. It's always very impressive. And your stuff is great too.
You both are. You all are. It's a pleasure to be here with you as well.
Thank you. My two of my longest mentors. It's always a privilege to work with them.
All right.
Thank you very much.
Have a great weekend, everybody.
All right.
Take care.
Bye-bye.
Thanks.
Bye.
Bye.